Welcome to the Bar Exam Toolbox podcast. Today we're talking about impeachment as part of our Listen and Learn series. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess, that's me. We are here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app. And check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com. And we'd love to hear from you. And with that, let's get started. Hi, and welcome back to the Listen and Learn series from the Bar Exam Toolbox podcast. Today, we are diving into part 2 of a 2-part series on the topic of impeachment. Impeachment is a subsection of evidence, which is a commonly tested area on law school and bar exams. If you haven't listened to part 1, I suggest you go back and listen to it before continuing with this episode, because we cover a basic review of both evidence and impeachment, which will be a good foundation for this episode. To briefly review part 1 of our impeachment series covering impeaching a witness's character, that is, questioning whether the witness themselves is reliable, today we will focus on impeachment of the testimony. In other words, is the information reliable? When opposing counsel seeks to impeach a witness's character, they are trying to show that the witness's testimony cannot be believed because it is coming from a person who cannot be trusted for one reason or another. When opposing counsel seeks to impeach a witness's testimony, on the other hand, they aren't calling into question the witness as a person. The witness might be the most incredible, trustworthy person ever. Instead, they are trying to show that what the witness is saying is unreliable in this instance and shouldn't be believed. There are a few rules of evidence that guide how counsel can properly question a witness's testimony. We'll go through the rules together and we'll tackle a few hypos, so by the end of the episode, you'll feel confident that you know how these rules apply in practice. Before we dive into the rules, remember the overarching goals of evidentiary rules: the admission of probative, relevant, reliable evidence, and only probative, relevant, reliable evidence to guide an adjudicator to a just outcome. With that, let's jump in. The first rule we will cover today is prior inconsistent statements. Prior inconsistent statements are admissible to impeach a witness. If a witness says one thing on the stand and the opposing party has evidence that the witness previously said something different, that statement can be introduced as evidence and used to impeach the witness. Note that the opposing party does not need to show or disclose the contents of the statement to the witness during examination. However, they must show it to the adverse party's attorney upon request. I also want to flag that introducing prior inconsistent statements does not necessarily prove that the prior statement is the true one. It merely calls into question the veracity of the current in-court statement. It will be up to the judge or jury to decide which statement is the most reliable. Sometimes extrinsic evidence of a prior inconsistent statement may be admissible. Extrinsic evidence is admissible only if 1. It is relevant to a material issue at trial, that is, an issue other than the witness's credibility, and 2. Proper foundation is shown, that is, the witness is first given an opportunity to explain or deny the statement, and the adverse party is given an opportunity to examine the witness about it. Finally, note that the rules about the admission of extrinsic evidence do not apply when the extrinsic evidence is being offered against a witness who is the party opponent. Let's move on to our second rule. I promise the final 2 rules will be shorter than the first. We got the most complex idea out of the way first, while our minds were the freshest. This is a great way to tackle your exam studying as well. Sorry, I couldn't resist a plug for good studying techniques. So the second rule. The rule deals with impeachment regarding a witness's ability to observe, remember, or relate the facts being testified to. This rule could arguably fall into either impeachment of a witness or of the testimony itself. I've included it in this second podcast because it is really dealing with the reliability, specific testimony, and the witness's ability to testify to it. However you want to categorize it is fine, as long as you remember that a witness's ability to observe, remember, or relate facts accurately may be attacked on impeachment, and that extrinsic evidence is admissible for this purpose. Our final rule today is about hearsay. Hearsay is not exclusively an impeachment rule. It is addressed more fully in episode 89, What is Hearsay? So take a listen to that episode if you haven't. Remember, hearsay is an out-of-court statement offered to prove the truth of the matter asserted. What I want to address today is using hearsay to impeach declarants. This is important. Just because testimony is not coming in live does not mean it can't be impeached. Testimony submitted as a declaration can also be impeached. Hearsay declarants may be attacked and then supported by any evidence that would be admissible if the declarant had testified as a witness. Further, evidence, including hearsay evidence, is admissible to impeach regardless of when or whether a declarant had an opportunity to explain or deny it. This means that having a witness testify via declaration does not get them off the hook. In fact, they may be less able to explain or defend themselves because they chose to participate in a static fashion and not in court. Great. Now that we've covered the three rules, prior inconsistent statements, ability to observe, remember, or relate facts, and hearsay declarant, let's take a look at some hypos adapted from previous California bar exams so we can see how these rules might appear on an exam and, most importantly, how to issue, spot, and best answer a question. So let's start with an evidence question from the February 2017 California bar exam. Pete sued Donna's Pizza in federal court. At trial, Pete testified that as he was driving his car one day, he entered an intersection with the green light in his favor. He further testified that when he entered the intersection, Aaron, an employee of Donna's Pizza, was driving a company van, ran a red light, and collided with his car. He sustained serious injuries as a result and was taken to the hospital. Pete then called Nellie, a nurse, as a witness. She testified that she treated Pete when he was at the hospital. Nellie testified that Pete told her that during the collision, his head struck the windshield and that he was still in a great deal of pain. Nellie, pursuant to standard hospital procedure, recorded the information on a hospital intake form. Pete moved the hospital intake form into evidence and rested. Should the court admit the hospital intake form? And if so, how could it be impeached? So what do you think? Should the court admit the form into evidence? How might the opposing side impeach it? Well, even though we aren't covering the full scope of evidence today, just to make sure we're building good habits, let's start where we always start with an evidence question, with the basics. Is the evidence relevant and probative? If it isn't, it should not be admitted. Remember, evidence is relevant if it tends to prove or disprove a material fact and should generally be admitted if its probative value is not substantially outweighed by the risk of unfair prejudice. Here, the hospital intake form includes Pete's statement to the nurse regarding his injury and how it occurred. Thus, it tends to prove a material fact, damages. Additionally, there is little chance of unfair prejudice here, as the statement relates directly to the accident and is not shocking to a jury. The form is relevant and probative, so it should be admitted. However, the opposing party might argue the intake form is hearsay. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Generally, it is inadmissible unless an exemption or exception applies. Here, the hospital intake form is offered to show that Pete was injured immediately after a crash. It was created out of court and is therefore hearsay. It is inadmissible unless an exception applies. Now, not only is the document hearsay, but it is arguably double hearsay. Documents or statements that have different layers of out-of-court statements are subject to double hearsay, and each statement must be analyzed for admissibility. Here, not only is the hospital form hearsay, as discussed, but Pete's statement contained within the intake form is also hearsay because it was made out of court and is being offered to prove its truth. Thus, both the form and the statement must apply to a hearsay exception to be admissible. If an exception applies and the court chooses to admit the out-of-court hearsay statement, the opposing party could impeach the hearsay declarant in the same way they would be able to impeach a live witness. The court may admit any evidence of the declarant's inconsistent statement or conduct, including statements that would otherwise be hearsay. So Donna's Pizza could impeach the statement by impeaching both the nurse who wrote the intake form and Pete who gave the statement. In this case, this isn't a huge risk to Pete because both Pete and the nurse are already being introduced as witnesses and may be impeached by Donna's Pizza. Trying to submit the intake form into evidence might be riskier if, for example, it were written by a non-testifying party who might be opened up to damaging impeachment. These are the kinds of analyses attorneys must engage in all the time as they prepare for trial. All right, let's continue on with this hypo. We still have Donna's Pizza's case to briefly discuss. During Donna's Pizza's case in chief, Erin testified that she had the green light and that it was Pete who ran the red light. In rebuttal, Pete testified that at the accident scene, Erin told him, "I was in a hurry to make a pizza delivery, and that is why I ran the red light." Assuming the court finds Pete's testimony about Erin's statements at the accident scene are relevant and probative, should it admit the testimony? Well, what do you think? Should the court admit Pete's testimony that Erin said, "I was in a hurry to make a pizza delivery, and that is why I ran the red light"? Under what theory? Donna's Pizza is likely to argue that Pete's testimony is hearsay. He is trying to introduce Erin's out-of-court statement for the truth of the matter asserted, that Erin ran the red light. But let's think back to our earlier discussion of prior inconsistent statements. Remember, prior inconsistent statements are admissible to impeach a witness. A prior inconsistent statement is admissible as an exception to hearsay. Here, Erin testified that she had the green light and that it was Pete who ran the red light. So to impeach her testimony, Pete testified that Erin had previously told him, "I was in a hurry to make a pizza delivery, and that is why I ran the red light." As this is a prior statement that is inconsistent with what Erin testified to at trial, it is likely admissible as impeachment, evidence under the prior inconsistent statement exception. Okay, I hope reviewing that hypothetical taken from an actual former bar exam helped you see how these issues arise on an exam and how you might tackle an answer to the question. Before we close out this episode, let's take a look at one more short hypothetical. After I read the question, feel free to press pause and think about your answer before listening to the analysis. Challenge your brain to think through the question and apply these 3 rules we discussed today. Lewis was driving a truck that struck Hank as he was riding his bike to work on a busy street during rush hour. Hank suffered painful lacerations, a dislocated shoulder, and a concussion that affected his memory of the accident. Hank filed a negligence action against Lewis. Prior to trial, the parties stipulated to the extent of Hank's injuries as well as his pain and suffering. At trial, Hank called Wanda to testify on his behalf. Wanda testified that she was also on her way to work that morning on her bicycle. She had seen both Hank and Lewis drive by shortly before the accident. She noticed Hank because he aggressively passed her in the bike lane and remembered Lewis's enormous truck, which was uncommon to see downtown. Hank then takes the stand. He testifies that he does cycle quickly and at times passes other cyclists. He also testified that Wanda was the only cyclist he passed that morning and that he never passes other cyclists when there are vehicles in the adjacent lane. In an attempt to impeach Hank, Lewis introduces evidence of Hank's concussion and resulting memory loss. Both parties make motions to exclude evidence and testimony. One motion Hank's counsel files is to exclude Lewis's evidence of Hank's concussion and memory loss. How should the court rule? Well, hopefully you took the time you needed to think about the answer to this question. As you become more comfortable with the rules of evidence, you will probably also spot other issues and arguments in this hypothetical. I hope you do. That is a sign that you are internalizing the rules and using your legal analysis and issue spotting skills, which are both imperative for a good exam score. Now that you've considered the question and answer, what do you think the court should do? I think the court should admit the evidence of Hank's memory loss. First, Hank's concussion and memory loss are relevant both to the accident itself and to the reliability of his testimony. They have a tendency to make the jury believe it is less likely that Hank's testimony surrounding the facts of the accident is reliable, meaning the facts he posits are less likely or probable. Though they are prejudicial, they are not unfairly so, since the evidence is not maligning Hank, but rather speaking directly to the reliability of his testimony and the facts of this case. The court should admit the evidence as impeachment evidence under the exception regarding a witness's ability to observe, remember, or relate the facts. Hank's ability to observe, remember, or relate facts accurately may be attacked on impeachment, and extrinsic evidence of this is also admissible. Lewis can introduce both testimony and extrinsic evidence regarding Hank's memory loss. This might seem unfair given that the accident, which may well be Lewis's fault, is the cause of his memory loss. Now everything he says is being called into question? Just remember that Hank can introduce and rely on other evidence to prove his case. His arguments won't be summarily thrown out, but it is relevant for the jury to know that if they are relying on his testimony about the accident, it might not be entirely reliable. Congratulations on getting through 3 more evidence rules, 2 more hypotheticals, and 2 podcasts just on impeachment. I hope this series helped you feel more confident in your ability to quickly and accurately analyze an evidence question. Evidence questions are repeat players on evidence exams, and you will need to be able to keep many pieces of information, many rules, and many exceptions in your mind. The more you practice and review, the better you'll be able to do just that. Good luck. That's all we have time for today, but we'll be back soon with another episode. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it, and be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.